I'd like to thank Mary for asking me to partake with you and to make a presentation today. It's an honor and a privilege to be associated with Caregiving Matters. I'm probably speaking to the choir here. You've probably been to their website, caregivingmatters.ca. If you haven't, or you're not as familiar with it as you should be, it's a tremendous site. There's all kinds of resources and information there, and quite frankly, the more information you have, the better you are to figure out how you want to and where you want to go and how to get there. And the Caregiving Matters website is just fantastic. Another website I'd like to plug, he said sheepishly, is my sister and I have a website as well, and it's called showmetherecords.ca, all one word, showmetherecords.ca. And that's a website we maintain and update on a quarterly basis in support of our book, Let the Records Show. We put together a newsletter called the Quarterly Ledger, which is filled each quarter with different practical advice and tips, question of the quarter, and these kinds of things to keep you updated and current on what's happening in the world of record keeping as it pertains to estate management and powers of attorneys. Today's topic for me are two topics I want to deal with. One is meeting with the lawyer, and the other is dealing with an estate audit. Now, this is the usual disclaimer you'll probably hear from the lawyers in the rooms today, is that this is a high overview. It's not meant to be exhaustive, nor is it a substitute for legal advice. If you're looking for legal advice, you need to contact a lawyer and sit down with them properly and deal with the issue. What hopefully you'll hear today is meant to give you some idea of issues that as they relate to meeting a lawyer and the estate audit regime. So let's talk about meeting the lawyer. Two preliminary questions that probably you're thinking about even before you start to meet with a lawyer is, first of all, why use a lawyer? In the age of the internet, notwithstanding my comments earlier that Mary's and my website are excellent tools, but search engines make us all experts at the click of a mouse. You fill in Google and all of a sudden you click and you get hundreds of thousands of potential hits, answers to your question. Yet in this internet age, the old adage that the lawyer who represents himself has a fool for a client is perhaps even more apt for those who are doing estate planning by themselves. Yes, there are will kits and power of attorney kits that are readily available, and for some, those kits might very well be a temporary solution. But however, in my 25 years of experience, I've never come across someone who hasn't been able to benefit from some practical and germane legal advice. The ability just to be able to sit down from someone and bounce ideas across or get objective feedback on, you don't get that from a will kit or a POA kit. Now, bear in mind that not every estate is complex or requires a staff of accountants and lawyers to map its future and manage its present. Nevertheless, there are tangible benefits in retaining competent legal counsel to ensure that the I's are dotted and the T's are crossed. For example, you want to make sure that things are done right so you don't have to worry about the details. This is especially true in cases where there may be contentious matters in your will, or your will may be open to dispute because maybe you've left somebody out or a disgruntled relative doesn't like the way you've arranged things. If you've done it properly and you've been to a lawyer and they've been able to walk through the steps that are involved to protect your bequest to people down the road, then you know that it's being done right. Second thing is knowledge and advice to help you build a better estate plan. A colleague, and I'm sorry I can't, her name escapes me, I can't credit her, but I heard this at a seminar she gave, and she said that her whole point was for people to make a better will, not a bitter will. And I think that really encapsulates the real purpose of what estate lawyers should be helping people to do, is to leave a better will, not a bitter will. A will isn't an instrument that you use to get back at people. You want to think very carefully so that you are leaving a better will and not a bitter will. Recognizing that every estate context is different, there is no one size fits all, but proper advice can help you attain and achieve your estate planning goals. Thirdly, going to see a lawyer instead of just dealing with a will kit is that you create an evidential basis for yourself and your estate if your will is ever challenged. In other words, your lawyer is doing more than just drafting documents. He or she is a witness to your capacity to make a document, to make a will in the first place, and also to attest to the fact that you're making that document of your own free volition. So, potentially when you think about it, going to see a lawyer actually is going to be doing a number of things for you that you don't want to forget about. Second preliminary question is, again, a practical one. Where do I find a lawyer? Well, past lawyers, for example, that you may have used on a house sale. Lawyers do different things. Some lawyers do nothing but real estate. Some lawyers have a mixed practice. They do estate work and real estate work and some other type of work. So it could very well be that you know a lawyer already. They did our house sale. Maybe they also do estate work, but you've got to ask them if they do estate work. Another place to look, obviously, is the Yellow Pages. You'll see lawyers advertising the estate specialty. The Law Society of Upper Canada has what's known as the Lawyer Referral Service, and that can also be a source of finding a lawyer. But perhaps the best source of finding a lawyer is word of mouth, is to ask a neighbor, a friend. Have you done your will? Who did you use? Did you like them? Were they accessible? Did you think you got value for the money that you spent? And that's usually how lawyers get their referrals. I've never advertised. All my clients have come to me because they either know me personally or, more importantly, by referrals. Someone has referred them to me because I did something for someone and they liked what I did, and so that and that kind of is kind of nice, because you know as a lawyer, yeah, I did okay for someone and I did enough of an okay job that they were kind enough to make a referral to a friend of theirs or a relative or what have you, and that's how the work comes in, surprisingly. The other thing to remember about choosing a lawyer is that lawyers charge different rates for different things. If your will is straightforward, then it shouldn't cost that much. And I'll be the first one to talk about the excesses of sometimes legal fees. But you've got to remember, lawyers have to pay taxes. They've got overhead. Have you looked at your hydro bill lately? Well, lawyers have to pay hydro too, right? And all of a sudden, what you think is, well, why is this costing, $300? Well, remember, that's not $300 that's going into the lawyer's pocket. That's $300 that's going into hydro's pocket, that's going into the taxman's pocket, that's going into supplies and all that kind of thing to keep the office open and running. However, having said that, I think you also have to realize that if your situation is complex and the will requires additional trust to be drafted and additional background work to be done in order to protect your estate, then obviously there's going to be a higher cost to that involved. However, you shouldn't be afraid to ask the lawyer, what are your fees? Sometimes we're a bit sheepish about, what's it going to cost? No, you shouldn't. It's just like any other commodity. Lawyers sell their services. They sell their time and their expertise. But they're just like anyone else in the marketplace selling that. And you as a consumer should understand what you're getting and why it is fixed like that. So you should never be afraid to ask the lawyer what his fees are, what are they based on, and why is it the way it is. The gospel imperative that the laborer is worthy of his hire is just as true for lawyers. But you've got to make sure that what you're paying the lawyer is commensurate with the services you're getting. The bottom line is, don't be afraid to shop around. Don't be afraid to ask about fees. A good lawyer should always be upfront about their fees and willing to discuss that issue with you.
You could give us a range?
Well, anywhere from an hourly rate. Well, if you're up here in this neck of the woods, hourly rates are somewhere, I think, between $300 and $500 or so. But lawyers don't always charge an hourly rate. Sometimes for a straight will, they'll charge a fixed rate. But other lawyers will charge an hourly rate, particularly if it's a contentious issue and there's a lot of drafting involved or a lot of meetings involved. Remember, at a certain level, the only thing the lawyer has to sell is his time, apart from his expertise. And if you're always on the phone talking with him, that's keeping him from other files or keeping him from doing other work. And I've found over the years one of the best ways to discipline clients is that, if they start to abuse you and all of a sudden they're calling you all the time, then you've got to put them on the clock, and that stops it. Personally, I don't mind taking a free phone call. I don't think you should have to pay for every phone call just because you're talking to your lawyer. That's just me. However, if the client's going to start abusing that and all of a sudden eating up my time with more phone calls than perhaps they should, then the best way to correct that is you start charging them. And then all of a sudden that takes care of that little problem. So let's talk about the meeting. And Mary did say action-packed day today, so let's get into the action and adventure. And by meeting, I'm referring not only to the initial meeting, but to all meetings and interactions you may have with your lawyer dealing with drafting and executing of the will. The first issue to deal with in the meeting issue is privacy. Older people, and maybe it's because of my parents' generation, but as we grow older, we tend sometimes to be a little bit more secretive. We don't like to discuss our affairs with strangers, let alone family members. And, you know, I'm a very private person, and that's just the way I am. And so all of a sudden I'm in with a lawyer and he's asking me all these questions. You know, does my lawyer need to know everything? And I know what you're thinking, don't lawyers know everything already? So why all the questions? Well, sometimes lawyers don't know everything, and I'll be the first to admit that I don't know everything. It's important that when you are having your will and power of attorney documents drawn up, you're doing more than just having documents drawn up. The documents are an end result of an estate planning exercise that entails your thoughtful consideration about your particular estate circumstances and arriving at a structure that's going to protect you and achieve your estate planning objectives. Your lawyer has an important part to play in that process by offering you objective assessment of what it is you want to do. He or she can only do that if they have the pertinent information about what it is you want to do and why it is you want to do what you want to do. In other words, the lawyer needs to understand the circumstances and goals that you're bringing to the table. For example, you may want to leave some money to a relative, a grandchild, or a son or a daughter, for example, but that relative suffers from an addiction to alcohol or drugs, something you're hesitant to discuss because it's, you know, the black sheep of the family. Well, if the lawyer doesn't understand, you don't mention this to the lawyer and he doesn't understand what it is you want to achieve here, they won't be able to provide you with advice about ways to leave the money to someone to protect them and wasting their legacy. In other words, by setting it up in a discretionary trust, so they can't use it all on booze or drugs or what have you. More importantly, by asking your lawyer, by asking you questions, your lawyer is establishing your, quote, testamentary capacity, and we'll get into that a little bit later. Something that's necessary if you want to make a will. You need to have testamentary capacity. The meeting with your lawyer is private. And I can't emphasize that enough. What is said in the lawyer's office stays in the lawyer's office. It's usually known by the more grandiose term lawyer-solicitor confidentiality or client-solicitor confidentiality. That confidentiality is the client's. It's yours. It's not the lawyer's. So the very fact that you even met with the lawyer, that's part of confidentiality. I can't confirm or deny that so-and-so has met with me. It's not for me to say. If you want to tell so-and-so I met with lawyer X, that's fine. That's your business because it's your confidentiality. The bottom line here is that the lawyer-client confidentiality exists to protect your privacy and to ensure that the lawyer knows everything to assist you in realizing your estate planning goals. So what's the lawyer's role at the meeting? Well, first of all, the lawyer should explain the process. The lawyer should explain, you know, what the planning and the process, drafting process about. It should include a discussion of fees if that hasn't been discussed earlier. The will may be the primary focus of your concern. I'm here to get my will drawn up. But you should also consider discussing, if you don't have them already, powers of attorney, because they're also part of a comprehensive estate plan. I've had a number of people over the years, they said, you know, oh, I don't need a will. I got so-and-so as my power of attorney. He'll look after me when I die. No. Powers of attorney die when you die. If you want your power of attorney to be your executor, that's fine, you can do that, but you need a will that gives him that authority because the will speaks from the day of death on. So it's important for people to realize that your estate really consists of, you know, what happens before the best before date when you're alive, and then the expiry date, what happens after you're dead. Powers of attorney look after you while you're best and good to go, but your will is going to look after you when you've died and your estate needs to be managed. Secondly, the lawyer should ask you questions about your current estate, who your intended beneficiaries are, and the disposition of your estate. Remember that a will does basically three things. Appoints your executor, provides for the payment of all your taxes and debts when you're died, and then the disposition of your assets, where you want them to go and how you want them to go. Asking you questions is part of the lawyer's job for several reasons. First, to offer advice so as to assist you in realizing your estate goals. Second, to ensure that you have testamentary capacity to make a will. Now, testamentary capacity means that the person writing the will is of sound mind, memory, and understanding when the will is made. Particularly, this means that you, the writer of the will, understand the nature and effect of the will, recollect the nature and extent of your property, understand the extent that what you are giving under the will, remember the people you might expect to benefit under your will, and understand the nature of the claims that may be made by persons you are excluding under your will. For example, sometimes in an estranged family, there may be reasons why you don't want to leave money to X, even though they're a close relative, a sibling, or a child. There could be very good reasons why you want no, I'm not leaving money to them. Well, the lawyer needs to understand that so that they know that you've thought it through, that you understand what you're doing, you understand that they could make a claim, you understand the consequences and why you're doing it. Conversely, maybe during the course of your life, you've left a lot of money, or you've advanced money to one child in particular. And that when you die, you want to recognize the fact that you've already given them a good chunk of your estate, so you're not going to leave them as much. Once again, the lawyer probing you in terms of why you want to leave your estate to your two children, 25, 75, can understand what the dynamic is, why it is what you want to do, and make the appropriate clauses in the will that spells out why you're giving one child more than another. The third thing the lawyer is going to do is the drafting of the documents. Nothing helps focus the mind more than seeing things reduced onto paper. It just has a way of crystallizing what you thought you were doing, and all of a sudden when you see it on paper, you go, that's not quite what I meant. Remembering that they're only draft documents, okay, and this is important to recognize in the larger context. One reason why people don't do wills is they feel that once they've written the will, that's it. It's carved in stone, it can't be changed. No. Lots of reasons to change a will over time. Your circumstances change, your estate change, people die, people come into your life, they leave your life. Because you've made a will once, doesn't mean you shouldn't be able to update it when you need to. Conversely, sometimes I've had people come in to me look at their wills, they're 20 years old, nothing needs to be changed at all. Just because you've made a will 20 years ago doesn't mean it necessarily needs to be updated. It could be perfectly fine. So the important point to remember is that a will can be changed. There are lots of reasons why you can change it. You shouldn't be afraid to change a will just because you've made it once. Same thing with draft. Sorry, yes?
Back to your previous point, how does a lawyer assess capacity?
Well, by asking you questions about, okay, who are your children, what are their ages, tell me about your estate, what's in it, and you enter into a conversation with someone. And after a while, you get a sense rather quickly of whether or not maybe they're a little bit, not quite there, or maybe they're a bit forgetful. Particularly with older people, you have to be careful of that and maybe probe a little bit more. But for the most part, people coming in, particularly younger people, you're not too worried about a capacity issue per se. You're more interested in understanding why it is they've decided to do what they do, and that's why you then engage in a discussion with them in a conversation. Does that?
With older people, if they go to redo their will, how then does a lawyer assess capacity if they're being brought in by, say, a sibling or something?
Okay, well, right off the bat, if someone comes in with a parent, for example, and they're in with mom, and the first point is you thank them for bringing mom into the office. Please give us a half an hour. There's a coffee shop down the corner, and we'll see you there. You want to meet with the client alone. You don't want to be in a situation where, so-and-so brought their mother in and mom was a bit fuzzy, but it was okay because the daughter was there and prompted her, and no. If it turns out that, and again, there are reasons why parents are brought in by their children, and that's fine. I'm not saying that shouldn't happen. What I am saying is that you as a lawyer need to meet with that person alone. so that you're assuring yourself that whatever it is they're telling you, they know what it is they're telling you, and they're doing so of their own free will. So just to return to the drafting, remember they are a draft document. Once you've seen how the legal structure of your intentions are and the language that's used, you may have additional questions. And remember, part of a will, it's a legal document. You're taking what you want, and it's being turned into legalese. And although we try to keep things somewhat simple, there are times when using legal phrases like a per stirpes distribution, for example, which is just the legal short form way of saying how the inheritance is to go through the generations if a top generation no longer exists. These are short form ways of ensuring that your wishes are fulfilled. But at the same time, you shouldn't be afraid to ask the lawyer, well, what does that phrase mean, and why is it there? The fourth thing, and again, it's very commonplace, but it's easy to overlook, but you need to have the proper execution of the documents. It's one thing to reduce your testamentary wishes to paper, but it's another to make sure that the paper is evidenced properly. In other words, it's signed and properly witnessed by two witnesses. That's only part of the process. At the time the will is signed, the lawyer should also prepare what's called an affidavit of execution. And that's just a document that makes the will an exhibit of the affidavit, but one of the witnesses signs the affidavit, swears it out, and they're swearing that they saw this document marked as Exhibit A. They saw it signed today by the testator. The other witness was in the room with me at the same time, and that the formalities were properly attested to. The reason that's important to have is that if your will ever needs to be probated, and we'll come to that in the second part, but if the will does need to be probated, you need to have the affidavit of execution with the will. And I think as a practical reality, you should expect, for convenience and practical purposes, that when your will is executed, the lawyer also does the affidavit of execution at the same time, so you've got a complete kit. You've got a complete package there. You don't need to go chasing a witness maybe 5 or 10 years down the road trying to find out who witnessed the will. So that's another important aspect, is that the lawyer is going to make sure that your will is properly attested to and the appropriate documentations are there. What about your role? Yes, you have a role to play, believe it or not, and you maybe have the most important role to play to make sure that your meeting with the lawyer is successful. And here are 4 aspects you should consider. First of all, meeting preparation. Prior to the meeting, you not only want to think about where you want your estate to go, but you also want to gather together appropriate information with respect to your assets as well as your beneficiaries, their addresses and their ages. In addition, you want to make sure that those who you propose to act as your executor or your power of attorney are willing to act. There's nothing worse than being surprised after the fact by finding so-and-so has named you as their attorney or their executor, and you had no idea. Maybe you don't want to act. Maybe there are other things going on in your life that make it impossible for you to act. So you don't want any surprises at that point, So you want to ask who you want your executor to be. Look, I'm making my will out. Will you be my executor? Second thing you need to do is, and again, every family is different. It's not a hard and fast rule, but you need to consider whether a pre-meeting discussion with family is appropriate. Your will is your own business, period. What you do in it until you die and it becomes a public document if it's probated it's your will. And there are many good reasons for not discussing testamentary dispositions beforehand. Nevertheless, there is nothing stopping you to ascertain whether some family members or friends, for example, would like a specific object of your estate, like a painting or a piece of jewelry or furniture. There are, of course, many of you, there is the potential looming headache, and maybe a speaker will talk about this later in sibling fighting, is the family cottage. Our time will not permit a complete recitation of the myriad of issues that can arise with dealing with a piece of property, such as a family cottage, that has a sentimental value that usually far outweighs its market value. Suffice it to say, talking through these issues before you die will make for a smoother transition under your will when the time comes. Third, questions. Don't be afraid to pose questions to your lawyer as to the whys and wherefore of doing things in a certain way. Remember, he's taking your instructions, you're paying him. You should be asking questions so that you feel comfortable with what's going on. You shouldn't be afraid to ask questions. And because part of the questioning, not only do you get answers, but it also helps the lawyer to understand your concerns. and part of that probing to making sure you have testamentary capacity, because by asking questions, you're showing you have an awareness of your property, you have an awareness of who your beneficiaries should be, and that whatever you're doing as a free voluntary exercise. Fourth, reviewing the draft documents. As noted above, nothing helps focus the mind better than seeing your instructions reduced to writing. This is your chance to make changes, to ask further questions to your lawyer to ensure that they've properly captured your instructions to create a sustainable estate plan. In other words, just because the lawyers drafted the document, don't assume that everything in the document is correct. Lawyers are human. Sometimes we make mistakes. Yes, even I make mistakes sometimes. And sometimes, if I've misspelt a name and my client has told me, oh, you've misspelled so-and-so's name, so you caught it then. Good for you. I know you've read the document. And let's face it, with this age of spell check, it's easy to go through a document and where are confused or so you have to pay attention. So those are basically the comments I wanted to make about the meeting per se. Should I take a question now about the meeting aspect? Okay, I'll keep going then. Okay. The estate audit regime. It's now required that those who submit a probate application, and I say probate in quotation marks because the nomenclature has been changed. It's now called a certificate of appointment of estate trustee, or a certificate application. When you now file that document after January the 1st, 2015, you now have an additional obligation to file with the Ministry of Finance an estate reporting return. It's a 7-page reporting form, and you have to do that within 90 days of the certificate of appointment being issued from the court. The estate information return requires the provision of detailed financial information to substantiate the valuation of the estate given for purposes of calculating the estate administration tax, or what we usually just colloquially call the probate fee. But it's a tax. And that is you pay at the time you make the probate application. So let's unpack this a little bit. First of all, this does not affect estates in which a certificate application has not been filed. So if your will doesn't need to be probated, and not every will does. I mean, usually, if a will has real estate in it, then yeah, you usually need to probate it because under the titles, the land title system, you need to have a probated will to transfer real estate. But if you don't have to file a certificate, then you don't have to worry about, because you're not paying any tax. So you don't have to worry about filing this application. And remember, when we talk about a probate application, it used to be probate if you had a will, letters of administration if you didn't have a will. Well, if letters of administration is now called a certificate of appointment of estate trustee without a will, another mouthful. I prefer letters of administration. But the point is, if you have to file an application, either if you have a will or you don't have a will, you're ending up paying an estate tax, and that means that you're going to have to file this estate information return. Certificates, as I said earlier, the certificate applications replace the old probate and letters of administration. And within 90 days of a certificate being issued, not 90 days of when you get the certificate, but when it's issued, and it shows on the certificate issued at Toronto on such and such a date, 90 days from that you have to file your information return with the ministry. The guide, by the way, and you can see this on the Ministry of Finance's website, is 13 pages long. So you might need a little bit of help filling it out, maybe not. As I said, the estate reform itself is 7 pages long. The estate regime exists to check the veracity of the estate's value upon which the estate tax has been levied. This means that assessment and audit powers, plus very broad powers of audit and inspection to administer the act, are given ministry bureaucrats. Inspectors have the authority to demand that any person, not just the estate trustee, provide information or documents or electronic records relating to the administration of the act. The Act further requires that estate trustees keep financial and accounting records related to the assessment for at least 4 years, because there's a 4-year time frame in which they can come after you to in effect audit your estate. Every certificate application, as I said, has to pay a tax to the Ontario government, At present, that tax is $5 for every $1,000 estate asset up to $50,000. So basically $250 on the first $50,000, and then $15 on every $1,000 or part thereof of estate asset. This means that an average estate of say 1.5 million, the estate tax is $22,000. If it's $1 million estate, the estate tax is $14,500. And the ministry can assess or reassess your estate for purposes of the tax within 4 years when it becomes payable. What's important to remember here is that the minister can also go after you beyond the 4-year period if you fail to comply with Section 4.1 of the Act, which is filing the required paperwork in the first place. So if you're late filing the paper, they can go after you beyond the 4-year period. And if there's any misrepresentation or neglect or carelessness or willful default is alleged, they can go after you beyond the time period. Failure to provide the required information, intentionally providing false or misleading information, etc., is an offense under the Act, and it's punishable with a fine ranging from $1,000 to twice the value of the tax payable, or up to 2 years imprisonment. So, I mean, it's an important recognition that this additional filing requirement, which is basically like another tax return, okay, you need to pay attention to and do it properly. Practical considerations then dealing with the estate audit regime, and there are 3 things I want to deal with here. Dealing with, and we've got lots of time. First of all, dealing with the ministry. Secondly, dealing with beneficiaries. And thirdly, dealing with the estate audit regime itself. Interacting with the ministry, it should be no different than dealing with the Federal Canada Revenue Agency. Remember that they're just bureaucrats doing their job that the legislation has given authority to do. If you don't like the new reporting and audit regime, and I know a lot of people don't for a number of reasons, blame your MP. Write to them and tell them that you want it repealed and gotten rid of. Don't blame the bureaucrats who unfortunately have got to administer it. They're just doing their job. And again, to be fair, to you, you've just lost a loved one. You've lost a parent, you've lost a sibling, you've lost a spouse, and all of a sudden, you've got all that paperwork, and now the government's telling you that on top of the terminal tax return you filed to the feds and everything else, you've now got to file another tax document, in effect, to the Ontario government of 7 pages length that details the financial situation of the estate. Yeah, that can be emotionally burdensome, but it's something that you're going to have to do. Once you file the document, there's some good news. First of all, you may never hear from the ministry at all. The current process, and again, because it's just newly come in, there's going to be some tweaking, but the basic rule is that once the return has been filed, you won't necessarily be contacted unless there's an assessment or audit done. There's no acknowledgement of the filing, at least not as yet. It's not like when you file your federal income tax return and you get a notice of assessment back, so they've got it, and you either owe nothing or you owe additional tax. That's not going on here. Secondly, as I said earlier, don't file late. If you file late, there's no limitation period on the timing for an assessment or reassessment. So you want to file on time. Third, if the estate is audited, remember to have all available and necessary documentation ready. It's just like if you were being audited by Revenue Canada. You want to have the supporting documentation that shows this is why I used this number for the value of the estate. So those documents would include, but they're not limited to, for example, the MPAC assessment on the value of a house, realtor's assessment as to the fair market values of any real estate, bank assessments, bank statements that you've got, investment accounts where you pulled the numbers from, professional appraisals of antiques, paintings, jewelry, boats, cars, that sort of thing, and any of the deceased's intention with respect to jointly held property. Usually jointly held property passes to the person who's also joint owner on right of survivorship, usually. Although new jurisprudence out of the Supreme Court suggests that bank accounts, for example, even though there's been a joint designation, don't necessarily go automatically to the survivor. They could be held on a trust basis for the estate. And in order to defeat that, you need to have something that the testator has signed saying, no, my intention is that when I die, my joint bank account that I hold with my daughter is to go to my daughter. It doesn't fall inside my estate. Fourth, if you provide complete and accurate information when requested, this helps to ensure the transparency. And the more transparent you are during an audit, it leads to a very timely resolution to any concerns that may have been raised by the audit. And finally, if in doubt, that's when you're going to need to seek knowledgeable professional advice to help you through the process. And we'll come to that towards the end. Dealing with beneficiaries. Okay, well, patience is a virtue, and no more so than you're dealing with government bureaucracies and with beneficiaries. The latter sometimes have a difficult time understanding why it's taking so long to get their request. You know, so-and-so dies in June, they've left money to people, or there's the residue beneficiaries, and now all of a sudden, you know, they're told, well, first of all, we've got to get the taxes done for the terminal year return, get the tax certificate done. That's going to be a couple of years, realistically speaking. And then we've got this Ontario audit issue. That could be 4 years, so I'm not sure when we're going to be able to wind up the estate. We'll just have to see how it goes. We can maybe make an interim disbursement, but that's not the same thing like getting all your money. You know, beneficiaries' chief interest is in knowing when they're going to get their inheritance. And that's not unreasonable, given the fact that the late departed meant their estate to be given to the beneficiaries in the hope that they would benefit from the bequest sooner rather than later. Anxious beneficiaries, however, can be a thorn in the side of an executor. But the best way to exercise that thorn is by apprising the beneficiaries of what's involved in the estate's administration, including the requirements of the new state administration tax reporting and audit regime. If you keep people in the loop so they know what's going on, then they're not going to be questioning you. They're not going to be wondering, well, what is going on? Well, you've told them. You've kept them in the loop. Especially the residue beneficiaries. Those are the people who get whatever is left of the estate after the specific bequests have been paid out. They need to understand that the estate administration has just become more complicated, has become more expensive potentially, and more time consuming, all thanks to the estate administration tax reporting and audit regime. Time to administer the estate. Beneficiaries need to understand that, practically speaking, simple estates with a straight distribution can now be increased to perhaps a minimum of 4 years to be in line with the assessment window that the ministry has. Remember that within this 4 years, as an executor, you're getting the taxes done, you're filing the final tax return, you're liquidating assets, you're getting the tax clearance certificate from Ottawa. That in itself takes a couple of years. So it's not like it's 4 years of dead space. No, there's a lot of things going on, and you may be in the position to give a fairly hefty interim disbursement when all that is done. But again, it depends upon individual circumstances. The important point, though, is letting the beneficiaries be aware that there's going to be time involved in administering the estate. Third thing is that, again, practically speaking, is that when you get the release from the beneficiaries, probably lawyers are going to be saying, well, we really need to get indemnification from the beneficiaries now to reimburse the estate if there's any additional fallout and taxes that are going to be paid because of an assessment. You want to make sure that as an executor that's covered off. And then finally, beneficiaries need to understand that there's going to be increased costs. These include accounting fees and legal fees, especially in cases where there is an audit. You may not want to go up against the government on your own. You may want to have the comfort of a lawyer there with you. Or if there's a disagreement, and we can all have disagreements, honest disagreements about the value of things. And if there is a disagreement about the assessed value of the estate, that's going to lengthen the time it takes to settle things. And also, beneficiaries need to be aware that you as executor, you're going to be doing more for the estate now. So that when it comes to the question of executor's compensation, that's going to have to also be taken into account in terms of why you've decided to take the full entitlement that you're required to under that. Finally, dealing with the estate audit regime as a whole. Like any new tax regime, there are many unanswered questions about its application, and they're only going to become known as the reporting and audit regime becomes more active. Nevertheless, there are some practical steps you can take now to safeguard the estate in your role as estate trustee. First of all, inventory preparation. An accurate and substantiated inventory is essential. And the book, let the record show, has steps there to help you through a proper inventory process. The inventory is a valuable tool in establishing the value of the estate, but now it becomes even more so because the estate tax man wants to know the particulars of the estate beyond the, quote, personal property and real estate net of encumbrances categories that are in the probate application form. Probate application form just asks those two categories. What's the personal property, which means, bank accounts, housing, personal effects, and then any real estate net of encumbrances, mortgages. That's in Ontario. That's the two things we want to know. The estate return, information return breaks that down. They want to know the nature of the property, the personal property, investment accounts, where they were held, the account numbers, personal property. And personal property could be a real practical problem. For example, I've had clients, older people now, that back in the 60s, they were picking up a group of 7 paintings for like $50 a pop. It just, they did it. That was fine. Well, those $50 paintings are now $250,000, $300,000 paintings. And that's the value they would be assessed for purposes of an estate audit. But that's, sort of an exception to the rule. Most of our personal property, our clothes, our household furnishings, as a practical matter, isn't worth much. Furniture. I had an estate a little while ago that we had to get rid of, and beautiful, beautiful cherry furniture, curved glass break front, really nice stuff. Should have sold for a couple $1,000, right? A couple $100. That's it. It's not worth what we think, partly because our society is changing. We don't entertain at home as much. So we don't think about furnishing our home with nice pieces of furniture. We live in an IKEA society, for good or ill. And so you've got to be objective, when you look at valuing a estate and figuring out, okay, what is this stuff really worth? And in order to do that, for example, you have Waddington's as example, an auction house come in, and they'll go through it and they'll say, well, no, that's worth putting on auction. No, not really that, no. And they will help you assess whether or not there really is a gem amongst all this stuff that you've maybe grown up with and loved yourself, but practically speaking has real no value. Document. I can't say that enough. It's worth repeating. That's why I said it 3 times. Document. It's the most important step that you can take when you're acting either as an estate trustee or as a power of attorney. You need to document all the transactions and property that are under your control. And indeed, you have a legal obligation to do so. As an estate trustee, the preparation of the inventory is only the first step in the documentation process. You also need to be able to substantiate the items in the inventory in terms of the value. Obviously, an impact statement and a realtor's appraisals are important in the context of real estate. Bank and investment account statements are also obvious sources of establishing the value of the estate's asset, the value of the account at the date of death. Professional appraisers of big ticket items, like I just said, someone from Waddington, for example, helps to establish paintings, jewelry, antique, boats, cars, etc., that need to be substantially valued. And don't forget joint accounts, as I earlier said. They need to be carefully considered to make sure that the intent really was to pass it to the person who's on the joint account and not really being held for the value of the estate, for the purposes of the estate. Remember that assets that pass outside the estate, for example, insurance proceeds, they don't form any part of the estate asset. That's, you don't have to worry about that. Get a bit of a break there. The amount of time taken by the estate trustee to deal with the apporting and audit regimes also you should carefully docket. Because it's going to be necessary. You'll need that to substantiate your claims when it comes to compensation. Estate trustees are going to have to do more work, and their compensation should reflect that amount of work. And the beneficiaries need to understand that, because that's why a claim is being made for $20,000 instead of $15,000. And that's coming off the top of the estate. That's less money the beneficiaries are going to get, but they need to understand why that is. Communications with beneficiaries, as I've said earlier, is an important. Keeping them fully informed will make your job as an estate trustee that much less onerous. It also helps to establish and maintain a proper sense of expectation, which helps to accompany the state administration. If people don't expect to get their money for a year or two, then that's the time frame they'll work with. If they don't know that, then they expect they're going to get it next month. And again, just to be fair, to keep everybody up on what's happening, you spell it out to them so they know what they can expect. Finally, professional assistance. While it may be necessary, and you shouldn't hesitate if it isn't necessary to require you so, to retain additional legal and accounting assistance to deal with the audit regime. At the end of the day, it is you as the estate trustee who are responsible for valuing the estate and paying the appropriate taxes. It's your responsibility. Even if you have lawyers and accountants helping you gather the details together, you're the one at the end of the day has to say, yeah, these numbers make sense. That's what I'm putting in the form, and that's what I'm swearing to when I fill out the application. You can lessen the administrative burden by being proactive by properly establishing the estate's accurate value and having the necessary document to support the valuation. In other words, when you go to make the probate application, you should already have the inventory done. You should already have the valuations in place. So you know that the two numbers that you put on the estate form are accurate, and that when you go to then break them down, when you get the certificate, the numbers you're going to break down, but the bottom lines are still the same because you've already done all the work you did when you made out the application in the first place. As for the rest, time and patience will get you through the complexities of estate administration. Unfortunately, you say death and taxes, the two things you can't avoid. Well, now it's death, taxes, and a death audit. That's just the way the cookie is crumbling right now. It doesn't have to be that way, but as I say, that's the way the current regime is in place. And the important thing as estate trustees is to ease that burden is by having a proper documentary trail and the evidence to back up why your numbers are they are. So, any questions? Yes?
Further to a question about capacity, what is the legal requirement for a lawyer to assess capacity if you have an elderly person changing their will, suffering from, say, dementia?
Douglas, can you repeat the question so that...
Okay, the question is, what is the legal or the lawyer's responsibility in a situation where an elderly person comes in, wants to change their will, but they're suffering from dementia? And that's an interesting question. And
since the lawyer will never have a baseline, it's the first appearance.
well, that's part of the issue. I mean, how do I know they're suffering from dementia? Well, because the daughters come in with her and said, well, mom's just been diagnosed with dementia and she wants to change her will. Well, I guess part of it is concerns, what changes does she want to make? If she just wants to change the executor, and there's a good reason to change the executor. And remember, dementia we're talking about capacities on a continuum. Because someone's been diagnosed with dementia doesn't mean all of a sudden they're a basket case and can't make decisions for themselves. So, you've got to be very careful in assessing, what someone is telling you this person has been diagnosed with. What's important for the lawyers to make their own independent determination, and if they need to talk to the doctor and need to get some medical issues, then they should. But again, you need to the lawyer will understand, and talk to the person, and if they have a doubt about, I'm not sure they have capacity, then they're not going to do it. They shouldn't do it. If I had a doubt about someone's capacity, I would not. I would, it's maybe heartbreaking, but if they don't have the capacity, if they don't understand, going back to that fivefold test I enunciated earlier, if they don't understand who the people are that they should be naturally benefiting, if they don't understand the nature of their property, if they already have a will, well, thank goodness they at least have a will. And then depending upon what the nature of the change they want to make, it could be very well, impossible to make.
My next question is probably a little more complex, but maybe better to do it offline. Let me ask a different one. Beneficiary or estate executor, what obligation is it upon them to disclose to the beneficiaries all the accounting and valuations for the estate?
Well, the beneficiaries have a right. The question was, what right do the beneficiaries have to an accounting of the estate? The answer is they have a complete right. People who have a specific bequest of cash, like $50,000, they get their $50,000 and that's it. They're away to the races. Residue beneficiaries, though, they have a right to an estate accounting. They have a right to know, and depending upon the complexity of the estate and how long it's been managed, remember the estate accounts form the basis for which a compensation claim is made. So the beneficiaries need to approve the compensation, or it needs to go before a court to have approval. And you need to have those documents, the accounts done showing what came into the estate, what you paid out under capital disbursements and revenue disbursements and income and what have you. And they have a complete right to know what that is. And it's part of transparency, right? I mean, you as an executor, you're administering the estate for the deceased, because she's asked you to or he's asked you to, but you're doing it for the benefit of the beneficiaries because they're the ones who are ultimately benefiting under the estate. And I don't know why anyone, I mean, I always tell clients transparency is best. What have you got to hide? It's A, not your property. B, the will tells people how the property is going to be, done. If beneficiaries have questions, then tell them. I mean, what's it is what it is at the end of the day. No, Mom didn't have $2 million. I'm sorry. This is what her accounts were. Here are the bank books. She only had $150,000 in her savings. And that's why the estate is valued.
How and at what point does the beneficiary make the request of the executor for that transparency? If it's not-
When does the beneficiary ask for that transparency? Well,
Especially when it's not coming from the executor.
well, again, this is something that we're kind of getting into the realm of specific legal advice. I don't want to get, because there are other factors I need to know about. I need
We
to
can
know,
take that offline.
like how long was it? What's the relationship? There could be a reason why there's no, at that point in time, why there's been no communication. I mean, maybe it's the person, the beneficiary needs to get in touch with a lawyer and have the lawyer write a letter. I mean, there are a lot. Every beneficiary or every executor, unfortunately, doesn't go to an estate lawyer to give them advice. Some people, they just think they can do it themselves. Well, good for them, and usually that's fine. But if there's going to be problems in the estate administration and people being people, and you'll probably get into this later in the day about siblings fighting over an estate, and the horror stories we can tell. It's sad, but it happens. And one way to avoid that in estate administration is by complete transparency. Yes, you had a question.
If you have a declaration of trust, can you avoid the probate?
The question is, if you have a declaration of trust, can you avoid the probate? You're only probating a will, and there are trusts in a will, but that you're probating the will. You could be talking the extent maybe where you have something called an ultra vires trust, where you've set up as a tax. I don't want to get too complicated to it, but it's basically a vehicle to put estate assets into this ultra vires trust, where you, as the settler of the trust, are the person who's solely the beneficiary. And then under the trust, when you die, it then goes to other people. So it doesn't really come in your will. So in that way, an ultra vires trust may be an appropriate vehicle. I mean, there are lots of vehicles to consider to avoid the probate, okay? Part of the issue revolves around, well, is your estate complex enough to take advantage of them? And unfortunately, it's a question of money. Setting up an ultra vires trust and administering it while you're still alive, you're going to have an accountant file a trust return for the estate, and there's going to be money involved in that. If your estate is small, it really doesn't make much sense. And let's also keep this in mind, right? That the probate fee is, $15 for every $1,000. It adds up. Yes, it does. But at the end of the day, it could actually be cheaper just to bite the bullet and go with probate. A perfect example is where you have stocks. Not in an investment account, but you actually own the stocks. Well, to cash out those stocks, usually the company is looking for a probated will. Or in the alternative, they'll say, okay, well, we'll let you cash these stocks out if you give us an indemnification and you post a bond. And when you start looking at the cost of the bond and the paperwork to do all that versus what the probate fee might have been, it's maybe simpler and quicker just to bite the bullet and get the will probated. So, I mean, every situation is different, and you need to, when confronted about it, you need to think about it and think about the long-term game in terms of, okay, what's going to be not only the cheapest but the easiest solution. Because usually, the easiest is best.
Right. One other question. In terms of IT, is it advisable to put password information in a will, or just pass it on to somebody you trust?
No, you want to keep, the question was, is it advisable to put IT information like computer passwords, bank passwords, that sort of thing, to put that in the will, or to keep it separate and pass it on to someone else? Don't put it in the will. Because the will, if it's probated, becomes a public document. That's the first point. Second point is sometimes, and this is true for funeral arrangements, by the way, some people put their funeral arrangements in their will. And it's been known to happen that someone dies, the will isn't the first thing people look for. They're thinking about getting mom or dad buried. And so they then go off to the funeral home, they pay $12,000, $15,000, $20,000 for a funeral, only to find the will next week and says, I want to be cremated. And all of a sudden, oh God, we spent $20,000 that we didn't have to. You need to tell your next of kin what your funerals are. You can either pre-arrange and let them know where you kept the paperwork in a safety deposit box or a safe place at home, or tell your children, your spouse, look, when I die, this is what I want you to do. Because I don't want you to spend a lot of money on a casket and embalming and all that kind of stuff. You know, some people do, and that's fine. Other people don't. But putting those kinds of instructions in a will, which is sometimes the document that isn't in the forefront when you start to do preparation planning, isn't necessarily a good idea. You want to tell your executor what your wishes are, because it's your executor that's actually responsible for seeing your burial arrangements.
Thank you.
Okay?
One more question.
Yes, one more question? Yes.
If you have a simple will and the assets just go to the surviving spouse, do you still have to do all the paperwork, and does it still take 2 to 4 years for everything to get transferred over?
Well, no, the good news is that, you know, if you're married, well, that is good news if you're married. But more good news is that usually what happens is that when the first spouse dies, everything's in joint ownership everywhere. Your bank accounts, your RIF rolls over without any tax consequences. Your property, your house is in joint ownership. The wife or husband takes by right of survivorship. You're not really worried about doing anything with a will, usually. It's when the second spouse dies that all of a sudden the parent's estate needs to be devolved to the children or the grandchildren or whoever. And that's when you will really get involved with the paperwork. So to answer your question, it's usually with the spouse, the paperwork is minimum. It's just a question of supplying appropriate death certificates to the bank to make sure that the spouse is, and that's the normal course. Now, if there's a family disruption, or if the spouses are separated, or there's family law issues involved, then obviously it's going to be more complicated than that. But just in your example of just straight, spouses are together, one dies, everything's joint. Do I have to? No, you don't need to worry about that. I don't think that's a problem. Well, thank you very much. You've been a great audience, as they say.